Welcome to the Deep Dive. We're tackling a really common, often frustrating situation in South Africa today. You get a court judgment, but, well, the debtor simply doesn't pay up.
That's right. And the usual methods, things like garnishee orders against salaries or emoluments attachment orders for other income, they frequently hit a wall.
They really do. Debtors can sometimes be quite skilled at avoiding these standard enforcement roads.
Absolutely. Think about a landlord, for instance. They get a judgment for unpaid rent, but the tenant's already moved, maybe left town, and owns no easily seizable assets like furniture or a car. The landlord holds a judgment, yes, but it feels purely symbolic at that point.
Just a piece of paper, really. And this is precisely why we're looking at Uniform Rule 45 of the Uniform Rules of Court today, specifically sub-rules 8 and 12.
Yes, these sub-rules are key because they deal with attaching something different, the debtor's bank account. It can be a much more direct way to satisfy the debt.
So our goal here is to explore how Rule 45, particularly these sections, gives judgment creditors another, often more effective strategy.
Indeed. And a critical point here is the concept of incorporeal property. Rule 45, 8, and 12 allow for attaching these intangible assets.
Intangible, so not physical things.
Exactly. And importantly, the Hanley case established quite clearly that the money held in a bank account falls into this category. It's considered incorporeal property.
Right, the Hanley case. That sounds pivotal. It legally classified bank funds in a way that makes them attachable under this rule.
Precisely. Before Hanley, there might have been some ambiguity, but the judgment clarified that a positive bank balance is fair game for attachment to settle a judgment debt.
So let's talk about how Rule 45, 8, and 12 actually work when those traditional methods like going after salary or physical goods fail.
Well, these sub-rules provide this specific legal authority. They empower the sheriff of the court, acting on the creditor's behalf, to attach these incorporeal assets specifically, the debtor's right to the funds held by their bank.
It's attaching the right to the money, not the physical notes and coins.
That's the essence of it. The bank owes the debtor money, creating a right, and Rule 45 allows the creditor to step in and claim that right up to the value of the judgment debt.
And the Hanley case really cemented this interpretation for bank accounts.
It did. It provided that vital judicial precedent confirming bank balances are indeed attachable incorporeal assets under Rule 45. It gave creditors and the courts clear authority.
Okay, this sounds powerful in theory, but how does it work practically? Say, I'm the creditor, I have my judgment. What are the steps?
The absolute crucial first step, ideally taken much earlier, is having the debtor's bank account details, verified details.
So you can't just ask the court to find the debtor's bank account.
No, generally not. The creditor needs to provide that information. This highlights why diligence before problems arise is so important.
You mean like getting account confirmation when you first start doing business with someone?
Exactly. For example, getting written confirmation of their banking details as part of your initial contract or onboarding process. It seems administrative then, but it could be invaluable later if things go wrong.
Okay, so assume I was diligent or somehow obtained the verified bank details. I have the judgment, I have the account number. What then?
Then you instruct the sheriff, through your attorney, to issue a notice of attachment specifically against that bank account, referencing Rule 45, 8, or 12. This notice is served on the bank.
And what does the bank do?
The bank is legally obligated to freeze the funds in that account, up to the amount specified in the judgment plus costs. They essentially earmark the money for the creditor.
So the debtor can't quickly withdraw it.
Correct. The funds are secured. The next step usually involves the sheriff demanding payment from the bank, and those frozen funds are then transferred to the sheriff, who in turn pays the judgment creditor.
That turns the paper judgment into actual recovered funds. It sounds far more effective, particularly if the debtor has funds but no easily seizable physical assets.
It often is. But again, it hinges entirely on having those accurate bank details. Without them, Rule 45, 8, and 12 aren't practically usable for bank account attachment.
So wrapping this up, the main point seems to be that Rule 45, underpinned by the Hanley decision, offers a critical tool for judgment creditors in South Africa.
Yes, it's a vital mechanism, especially when debtors aren't complying and traditional enforcement fails. It directly targets available funds.
But the effectiveness really depends on preparation and foresight. Gathering that banking information early is key.
Absolutely critical. Diligence at the start of a relationship can make all the difference if enforcement becomes necessary down the line.
It certainly makes you think about the balance. For creditors, it's a powerful recovery route. For debtors, it underscores the serious consequences of not meeting obligations if they have funds available.
It does. And perhaps a final thought for you, our listener, to reflect on. Knowing that this mechanism exists, the ability to attach funds directly from a bank account, how does that shape your view on financial responsibility and the real teeth behind legal judgments in South Africa? Something to consider.